Before we start, I just want to first acknowledge that I'm joining the meeting from Gadigal land, and I pay my respects to elders past, present, and emerging. So yeah, thanks everyone for attending today. By way of introduction, my name's Grace Cameron Lee. I'm the practice lead of the Police Accountability and Generalist Practice at Redfern Legal Centre. Just a really quick overview, the Police Accountability Practice at RLC is a statewide service. So we provide advice about police powers, including improper use or unreasonable or unlawful use of police powers. We advise on things like accessing police records, victims' rights, making complaints against police, bringing civil claims against police, and discrimination complaints against police. So we're primarily an advice service, but we do occasionally assist clients with some ongoing casework, and we do things like provide community legal education, and we do a lot of law reform advocacy work as well relating to policing issues. I just want to let everyone know that we'll have some time for questions at the end. So if you have a question, that's great. You can type it into the Q&A function on the Teams, and we'll have a look at those at the end, and hopefully we can answer all your questions. Okay, so I just got to work out how to do my. Okay. So the purpose of today's session is to understand the application of anti-discrimination laws when people experience unfair treatment or discriminatory conduct by New South Wales Police. So I suspect many of you have joined the webinar today because you worked with a client who felt that police had treated them unfairly, perhaps because of their race or disability or gender or sexuality or mental health or some other reason. And so this session is really about what is and what is not covered by anti-discrimination laws in relation to police conduct, and then also what other accountability options might apply when it comes to discriminatory conduct by police. So I guess it's important to note from the outset that not everything unfair is illegal or is unlawful discrimination, and that can actually be very frustrating. So hopefully I'll be able to kind of explain a little bit more about that in the session today. So in New South Wales, we have both state and federal anti-discrimination laws. And both the federal and the state laws apply in New South Wales. So I've listed the relevant legislation on the slide. These anti-discrimination laws are really designed to protect some people from discrimination in certain contexts. Anti-discrimination laws in Australia are influenced by international law and Australia's, international human rights obligations. Australia is a party to several key international human rights treaties that prohibit discrimination. And we uphold our obligations under these treaties by creating domestic anti-discrimination laws. So there is some crossover between the state and the federal legislation. Some of the state legislation covers similar conduct that the federal legislation does, but often the federal legislation is a bit broader. And I will talk a little bit more about the difference between the two jurisdictions a little bit later in the presentation. So when it comes to discrimination law, generally, there is often a common misconception about how it applies. So I often, hear people say something like, I was treated badly and I have a disability. That must be unlawful discrimination, right? Well, that's not entirely correct. The law doesn't actually prohibit all unfair treatment. And anti-discrimination law only applies in specific situations and requires sort of specific proof. So the fact that a person might feel discriminated against is really important, but that's only the starting point. That's actually not the legal test to determine whether the discrimination is unlawful. So to prove unlawful discrimination, you need to show 4 things, basically. And I'm talking in this context about direct discrimination. I won't really cover indirect discrimination too much in this session. But what you need to prove is that a person was treated less favourably because of their protected characteristic, which I will discuss in the next slide, compared to another person without that protected characteristic in a particular area of public life, such as the provision of services, employment, or education. So a very sort of simple example is that, person A is a man and person B is a woman. Person A and person B both report being victims of a very similar crime to police, and they report that crime in the same or similar circumstances. Police might respond respectfully and take a statement from person A, but dismiss person B, refusing to take her statement and telling her that police can't assist her. That in and of itself is not enough to prove discrimination on the basis of sex. The hard legal question is why person A and person B were treated differently. If it can be established that the reason person B was treated less favourably than person A is at least in part because person B is a woman, rather than some complete other reason, then that would be unlawful discrimination. So I'll move on to protected characteristics. Protected characteristics are sometimes also referred to protected attributes. That language is interchangeable. I'll try and refer mostly to protected characteristic today. But anti-discrimination laws only prohibit discrimination on the basis of some protected characteristics. And those are listed up on the slide here. So, you might look at this list and think, there are other bases that police or other organisations or people might discriminate against a person that aren't covered by this list here. And that's certainly the case. And there has been consideration of what are other protected characteristics that probably should be protected. And some examples can include sex work, religion, irrelevant criminal record, domestic and family violence, and socio-economic status. So there is certainly some calls among the community to expand these protected characteristics, but as it currently stands, discrimination is only unlawful on the basis of these protected characteristics. Importantly, anti-discrimination laws don't make discrimination unlawful in every single context. So they don't protect people from discrimination in any aspect of life. anti-discrimination laws really only make discrimination unlawful in the context of limited areas of public life. These include work, accommodation, education, and the provision of goods and services. Some of the federal laws do also prohibit discrimination in other areas of public life, including clubs, which is an association of 30 or more people. So think like sporting clubs, political clubs, social clubs, that sort of thing. And some federal laws also prohibit discrimination on the basis of administration of Commonwealth laws and programs. So that could be, for example, like the administration of a Commonwealth grant or something like that. But generally speaking, discrimination is really only prohibited in a sort of small number of public situations. The kind of main and important exception to this, which I will discuss a little bit more later in the presentation, is the Racial Discrimination Act, which does apply to all areas of public life. So it's much more expansive than most other discrimination laws. So I guess the other point to kind of quickly touch on here is that anti-discrimination laws also prohibit other conduct, not just discrimination. So that can include things like sexual harassment, which is unwanted or unwelcome sexual advances or engaging in conduct of a sexual nature. Vilification, which is the incitement of hatred, serious contempt, or severe ridicule of a person or groups of people on the grounds of race, sexuality, HIV status, and victimization, which is subjecting a person to detrimental treatment for making a discrimination complaint or for alleging discrimination, and that usually occurs more in the context of work or sometimes education, where an employee might be subjected to some retaliatory conduct for raising a discrimination complaint. So getting to the kind of meaty part of the presentation today, the question then is, do anti-discrimination laws cover the conduct by New South Wales Police? Can police be held liable when exercising their powers or when dealing with members of the public under these anti-discrimination laws, particularly when we consider that generally these laws only apply in certain areas of public life, such as work, education, accommodation, or the provision of goods and services. So I guess the question that is kind of asked is whether police are providing a service, because generally the functions of police conduct is not going to fall into the categories of work, education, or accommodation. So the only place we could try and fit it is in provision of services. And so, so the question is, are police providing a service? And courts and tribunals have considered this question in relation to different policing contexts. And those decisions have kind of determined that in some contexts, yes, police are providing a service, and in other contexts, no, they're not. We can kind of, I guess, narrow it down to two broad contexts, largely speaking, in terms of police conduct. The first context is when police are exercising their powers against a person. And then the second context is when police are, responding to a call for assistance or dealing with a victim of crime or dealing with somebody trying to report a crime. So we break it down into those two contexts to answer this question about whether police are providing a service. So I'll start with exercising police powers. So as some of you might know, police have special powers under legislation to carry out functions. The main legislation that gives police their powers is LEPRA, the Law Enforcement Powers and Responsibilities Act. But there are other pieces of legislation that give police powers. Those kinds of powers include things like stop and search, the power to stop and search, the power to arrest, the power to charge somebody with a criminal offence, and decisions around whether or not to grant a person bail once they have been arrested and charged. So I guess courts and tribunals have considered whether police are providing a service in this context and therefore whether anti-discrimination laws apply. And generally, in this context, courts have found and tribunals have found that police are exercising statutory functions when they're using their powers against a person. They're not providing a service to an individual who is the subject of the police power. So therefore, police in these contexts are generally not subject to anti-discrimination laws. I'll just give you a couple of kind of case examples. The first is the case of the Commissioner of Police and the estate of Edward John Russell. Edward John Russell was a First Nations man, and he was pursued and arrested by police in Oberon in 1993. So this is quite an old case. It was alleged by Mr. Russell that the officers in carrying out his apprehension and arrest unlawfully discriminated against him on the grounds of his race and subjected him to racial vilification in breach of the Anti-Discrimination Act. Sadly, Mr. Russell passed away while the discrimination proceedings were on foot, but his parents carried on the claim. And the matter was referred to the Supreme Court to deal with this question of law, which is, whether police are providing a service to somebody within the meaning of the Anti-Discrimination Act when they're pursuing and arresting a person. And the court held that when pursuing and arresting Mr. Russell, the police were providing a service to the community at large. They weren't providing a service to Mr. Russell and therefore are not subjected to discrimination laws in that context. And that's a really key case for the authority that police are not providing a service in these kinds of contexts. The other case I just wanted to touch on as well was the case of Robinson and the Commissioner of Police. And this case involves a man, Mr. Robinson, who lives with a disability as defined by the Disability Discrimination Act. He was arrested in 2009 on fraud-related offences. During his arrest, Mr. Robinson appeared to suffer from a seizure. But the arresting officers formed a view that Mr. Robinson was faking the seizure. Nevertheless, police called an ambulance and Mr. Robinson was conveyed to Liverpool Hospital with police guard. And, later on he was released into police custody and taken to Liverpool Police Station. The police fax, which is the document that police prepare when they're, charging somebody with a crime, the police fax were written by the officer that arrested Mr. Robinson, and they said, the accused appears to suffer from mental illness, but police strongly believe that this is a feigned illness and an attempt to utilise the benefits of the Mental Health Act in the judicial process. So Mr. Robinson was eventually released on strict bail conditions by the police. He was granted bail by the police. And the senior police officer who granted bail seems to have relied on the comments in the police facts by the arresting officer in making a bail decision and applying strict bail conditions. The bail decision said Mr. Robinson has been treated under the Mental Health Act previously. Police believe this is an act by the accused to utilise the system. Reporting conditions are to apply and monitor. So Mr. Robinson brought a complaint against New South Wales Police under the Disability Discrimination Act, alleging, among other things, that police discriminated against him on the basis of his disability in the way that his arrest, his conveyance to hospital, treatment by police in hospital, and the subsequent bail decision was handled by police. This matter, because it was under the federal and the Disability Discrimination Act, was heard in the federal court, and the court found that New South Wales Police were not providing Mr. Robinson a service when they arrested him or when they were making a decision about granting him bail and what conditions to apply. These were exercises of statutory functions by the police. They weren't the provision of services to Mr. Robinson. And the same vein, the court held that Mr. Robinson's conveyance to hospital, the police's conduct and presence at hospital were not a service to Mr. Robinson, but part of the, management of his custody and the police investigation into the fraud charges. So they said that was a statutory function and not a service to Mr. Robinson. So I guess what's the issue here? From what, putting to one side these cases and the merits of those cases that I just discussed, certainly something we see in our practice is that some of the worst discrimination by police occurs during arrests, during stop and search, when police are exercising their street policing powers. And these powers are often used disproportionately against vulnerable and disadvantaged communities, including First Nations people, people with a disability, culturally and linguistically diverse people, and also members of the LGBTQIA plus community. So it's troubling that New South Wales Police are generally not liable under anti-discrimination laws when exercising their powers in a way that might be discriminatory. So yeah, that's just something to think about, and I'll talk about this issue a little bit more, but I just want to move on now to talking about the other main context where discrimination laws might apply in relation to police. So I guess a big part of the role of the New South Wales Police is to assist victims of crime and, respond to calls for help and provide protection to people. And courts and tribunals have considered whether in this context police are providing a service to the person seeking assistance. It's been determined that the initial response by police and early investigation can be considered a service to the person who's seeking assistance or protection from police. But later decisions, like decisions about how to conduct the investigation, whether to actually charge or prosecute the accused person, those are not services to the victim. They're again policing functions, and so those sorts of decisions are not subject to anti-discrimination laws. So I'll just also give a quick case example of this. This is the case of the Commissioner of Police in Mohammed. So in 2007, Miss Mohammed and her family, who are of Arab Muslim background, were allegedly abused and assaulted by their neighbours in Blacktown. Miss Mohammed called the police. 2 officers attended the scene, but behaved, in a rude manner towards Miss Mohammed and her family. They refused to take the complainants seriously. They didn't take any action to protect the complainants from the alleged perpetrators. So generally just sort of failed to assist the Miss Mohammed and her family. Ms. Mohammed brought proceedings against police under the Anti-Discrimination Act, alleging racial discrimination by the officers, in the provision of services and their failure to provide her with services. This matter was referred to the Supreme Court to address this question of law, which is whether police are providing a service to the person who is seeking assistance. And the court held that the police conduct in response to a request for assistance, particularly where a person is seeking protection of themselves or property, that can constitute the provision of service or the refusal to provide a service. But as I mentioned previously, that only relates to kind of the initial response by police. It doesn't relate to kind of later investigation conduct or, decisions about arrest and prosecution. So I'll move on. So I guess to summarize, that first question of whether police are providing a service is going to kind of largely depend on the context of the policing power and what police are doing. And that's just kind of the first hurdle of proving discrimination or bringing a discrimination claim against police. The next part is to determine whether you can prove discrimination. So if we go back to the start, I set out that sort of 4-part test for proving discrimination. That, someone has to prove they were treated less favourably because of their protected attribute compared to a person without that protected attribute in a particular area of public life, such as provision of services. So I want to talk about, the next hurdle, which is the comparator test. So determining whether a person was treated less favourably compared to somebody who doesn't have the protected characteristic. This is called the comparator test. And the law asks, would the discriminator have treated someone else without that characteristic different in the same or similar circumstances? The comparator test can be, quite difficult to grapple with. It's actually quite a legally confusing test. There's often no real-world comparator that you as the person complaining can point to. We rarely have a situation where, you're maybe a cisgendered female and you're, going up against a cisgendered male in a promotion, you're equally qualified and they give the promotion to, or you're maybe more qualified as the cisgendered female and they give the promotion to the cisgendered male. That's, a nice easy case where we can say, oh, look, there's the comparator right there on a platter. Most discrimination complaints will not have that situation where there's a really easy comparator to point to. So what you're usually doing is you're having to create a hypothetical comparator based on the contextual factors or the broader contextual factors of the discrimination and the situation. So that can be quite tricky to do. The other kind of aspect that makes the comparative test a little difficult is that it can sometimes be tricky to determine who the correct comparator is. So it's not always as simple as that example I had of, you know, a cisgender woman alleging discrimination on the basis of sex, where it would be fairly easy to say, well, the correct comparator is a cisgender male. Often it's much more complicated than that, particularly when you're looking at things like disability discrimination. And, you know, for example, with disability discrimination, there are often behaviours that are a manifestation of somebody's disability. And the, you know, question also often comes down to whether the correct comparator is a person who doesn't have the disability but does have the same behaviours or manifestations of the disability, or whether the correct comparator should be a person who doesn't have the behaviours or manifestations of the disability. And so that can be like quite a difficult kind of legal test to meet and to think about. And the difficulty as well is that the burden sits almost entirely with the person who's making the complaint to establish the comparator, when that person is often not the one who has access to the evidence available to show that they were treated less favourably than somebody without their protected characteristic. So the comparator test can be quite legally confusing and difficult to establish. And so, you know, in my view, it's not actually necessary. It shouldn't be a part of the test for discrimination. But that is currently what, in most anti-discrimination law, what somebody has to prove. The second part of this test is that a person was treated less favourably because of their protected attribute. So the because of part of the test is also often quite tricky to establish, because there needs to be a direct link between the unfavourable treatment and the protected characteristic. So there needs to be some causation. It's not enough to have correlation. So, you know, the fact that somebody is a person living with a disability and they were treated unfavourably without there being a clear link between the two. So you can understand that, again, this might be quite tricky to establish, because discriminators rarely, you know, say outright, oh, I'm doing this because you're Aboriginal, or, you know, I'm treating you this way because you're a woman. You know, it's not always really obvious on the evidence, or really clear evidence that can be pointed to say, yeah, that's the link between the unfavourable treatment and my protected characteristic. You know, and often it's, the bias can be kind of unconscious and hard to prove. It's not as overt as, you know, as it could be. So it's, you know, it can be really hard to say this is the evidence that we're pointing to prove causation. And, you know, the difficulty of all of this is that, again, the onus is on the person bringing the discrimination complaint to prove this because of element. So to prove that they were treated less favourably by the discriminator because of their protected characteristic. And so, yeah, so it can be kind of tricky to get that sufficient evidence to prove. But you will often, you know, when there's no direct clear link, you'll be able to rely on contextual factors in the discrimination in the context of the discrimination and what happened, to say, this is why, I say that I was treated this way because of my protected characteristic. I'll just quickly mention another real-world case example. This is the case of Weldon Bowen and the Commissioner of Police. So Miss Weldon Bowen is a First Nations woman, and she brought a complaint against the New South Wales Police for sex and race discrimination under the New South Wales Anti-Discrimination Act. The crux of the complaint was that police failed to appropriately investigate a road rage incident that she was involved in, that she reported to police, which involved herself as the driver and a cyclist. She alleges that the cyclist punched her car and abused her after the cyclist alleged that Miss Weldon Bowen overtook him in what he says is an unsafe manner and then brake checked him. Miss Weldon Bowen attended the police station to report this incident to police and alleges that the officer at the desk who took her report discriminated on the grounds of race and sex in refusing to allow her to give a formal statement, failing to assist her, failing to allow her to speak to an Aboriginal liaison officer, and dismissing her complaint and actually issuing her with a fine for negligent driving, which was dismissed in court. The police disputed that the conduct of the officer taking the complaint, taking the report from Miss Weldon Bowen was a service within the meaning of the Anti-Discrimination Act. The matter came before the New South Wales Civil and Administrative Tribunal, and the tribunal determined that, in fact, police were providing Miss Weldon Bowen a service. They were, responding to her request for assistance and initial complaint. However, the claim fell over on these other tests, the comparator test and the because of test. So the tribunal determined that there just wasn't enough evidence to establish that Miss Weldon Bowen was treated less favourably than a comparator, someone without her protected attribute, and that it wasn't reasonable or logical to draw an inference from the evidence that the police officer who took her complaint was sort of treated her in the way that he did because of her race or sex. It was held that the police officer's investigation and dealings with Miss Weldon Bowen reflected more his incompetence and bias against drivers as a cyclist himself. And so there wasn't sufficient evidence to say that the treatment was actually because of Miss Weldon Bowen's race or sex. So that's an example of where, you get up on this, are police providing a service, but the complaint falls over on whether you can establish or prove discrimination to the quite high legal standard. And I guess it just goes to show that anti-discrimination claims often fail, not because the discrimination didn't happen or not because there was a bias. It's because it's really difficult to prove discrimination to the legal standard. And I just want to kind of on that note talk a little bit about law reform. So obviously we've been talking about the limitations of anti-discrimination law in relation to New South Wales Police. And so, there's certainly gaps in the law and a need, in our view, for reform. The Anti-Discrimination Act, the New South Wales legislation, is currently under review by the New South Wales Law Reform Commission. Submissions were received last year. RLC, our organisation, and I think many others, made a submission to that review and argued for several changes, including the protection against discrimination in all areas of public life so that it would cover all conduct by police, the removal of the comparator test and replacing that with just a simpler unfavourable treatment test, so just proving that you were treated unfavourably, not having to work out a comparator and prove that you were treated less favourably than them. And we also recommended a fairer burden of proof. So shifting the burden of proof, meaning once a complainant demonstrates that they were treated unfavorably, the burden would then shift to the respondent, person being, the discriminator, to demonstrate that the complainant was not treated unfavorably because of a protected attribute, that they were maybe treated that way for some other reason. So that's what we've called for, and that review is still ongoing, and don't expect to get a final report from the Law Reform Commission for still quite some time. The other kind of area for reform that's kind of in the works at the moment is that the New South Wales Parliament is conducting an inquiry into the establishment of a Human Rights Act. So we've discussed that, there is some legal protections against discrimination in New South Wales, and these protections apply really only in some areas of public life, and they're really only to protect against discrimination for some people. They're really quite narrow, I guess. But, our anti-discrimination laws really don't provide, I guess, a broad, comprehensive protection on human rights more generally. And they're not enough to really address systematic and entrenched discrimination, particularly in institutions like the New South Wales Police Force. And to properly kind of address these entrenched issues, what we really need is broader human rights legislation. And, a Human Rights Act would differ, I guess, from anti-discrimination law, because rather than focusing on, specific protected attributes or complaints that can be lodged after the harm is already done, a Human Rights Act would set sort of a broad charter of rights and place positive obligations on governments to consider rights when, implementing laws or policies. So I guess if you do work with vulnerable or disadvantaged communities, you might want to consider making a submission to the parliamentary inquiry. And information about the inquiry is available through the New South Wales Parliament website. And you can also find some more information on the Human Rights Act for New South Wales website as well. Okay, I was going to just briefly touch on the Racial Discrimination Act because as I mentioned, the Racial Discrimination Act can actually apply more broadly to police conduct because it prohibits racial discrimination in all aspects of public life. So that can actually extend to police using their powers against people. And so the legal test requires, that the person who's being discriminated against just establish that there was some sort of distinction or exclusion or restriction or preference based on race, which has the effect of being racially discriminatory. And it can apply even when, police didn't intend to discriminate, but the impact is still racially harmful. So, so this is a much kind of broader scope, and if there is examples of discrimination on the basis of race by police, there is much more of a scope to be able to bring these claims under the Racial Discrimination Act. There have been some kind of high-profile cases under the Racial Discrimination Act against police. One is the racial profiling case in Victoria, the Hallie Michael case. And these were legal proceedings brought against Victoria Police, alleging that Victoria Police had kind of unlawfully targeted and used their powers against African and other racialised young people in northwest Melbourne. And the case was brought under the Racial Discrimination Act. It was actually settled by police. So we don't have a court decision, a final kind of court ruling on it, but it does show that certainly racial discrimination cases brought against police can be successful. I'll just move on, noting the time. So making a discrimination complaint, if you do think you have a discrimination complaint against police, after kind of thinking about all of these, the 4-point test that I set out, what can you do? Well, you can bring your complaint under either the federal law or the state law. You can't bring a claim under both. So you do have to decide which law best applies to your situation, or which law is going to give you the best outcome. There's several factors that will come into play into deciding which jurisdiction to go with. So it's really recommended that you get legal advice before you lodge a complaint. Complaints under the Anti-Discrimination Act, the New South Wales legislation, are directed to Anti-Discrimination New South Wales, and a complaint under the federal legislation would be directed to the Australian Human Rights Commission. Now, you do have to lodge your complaint first with one of these two commissions before you can bring your claim to the court. So the Human Rights Commission and Anti-Discrimination New South Wales, their role is to kind of receive complaints and assist the parties to engage in conciliation, so to see if there can be a resolution of the complaint. If there can't be a resolution of the complaint, then you as the aggrieved person or the person complaining can take your matter off to the court or the tribunal. Just a quick note that there are some time limits on bringing complaints. So you have to bring your complaint to the Australian Human Rights Commission within 24 months and the Anti-Discrimination New South Wales within 12 months. But note that there is discretion to accept a complaint that's out of this time frame. So even if the incident occurred more than 24 months or 12 months ago, you can still make your complaint, explain why you had the delay in making the complaint, and the complaint might still be accepted. So just finally, kind of talking about police accountability, it's important to note that discrimination is not just kind of unlawful, but it is also police misconduct. So the New South Wales Police Force Professional Standards and Professional Conduct Code states that all New South Wales Police Force employees must act with fairness and impartiality to other employees and customers, so anybody, and must show tolerance to all individuals, their traditions, beliefs, and lifestyles. So it expressly, the Code of Conduct expressly makes it unlawful to discriminate against any person on the basis of a number of protected attributes which are set out on the slide there. So even if police conduct, discriminatory conduct by police might not be unlawful under anti-discrimination law because you can't meet that service requirement or unable to sort of prove discrimination, it is still police misconduct. And so you can still make a complaint about the conduct. And I guess the key difference between, bringing in a discrimination claim and making a complaint is that if you have a basis to bring a claim under anti-discrimination law, you can seek financial compensation. Whereas a misconduct complaint is really more about accountability. So it can lead to things like internal disciplinary action against police officers or an apology, but it doesn't lead to financial compensation to you as the person complaining. Police complaints can be lodged either directly with the New South Wales Police Force or to the Law Enforcement Conduct Commission. The Law Enforcement Conduct Commission is the independent oversight body for New South Wales Police. So you should be aware, I think, I'll note that even if you make your complaint to the Law Enforcement Conduct Commission, it can really only internally investigate matters of very serious police misconduct or maladministration. So generally speaking, complaints about police discrimination are not going to meet that threshold. So the LEC is unlikely to internally investigate those complaints. What they'll do is they'll refer those complaints back to the New South Wales Police Force to be internally investigated. As I mentioned before, complaints, what will happen is the complaint will be investigated. It will be either sustained or not sustained. And you should be told what the outcome is. And if the complaint was sustained, you'll be told generally what action was taken by police. Sometimes police do close complaints without investigating further under Section 123 of the Police Act, so that might be the outcome as well. So yeah, but you should get told what the outcome of your complaint is. I mean, I've had success in the past with making complaints about discrimination by police, where police have investigated and made determinations that the complaint was sustained and disciplinary action was taken against the officers. So just before we get to questions, I just wanted to provide some key takeaways for the session today. So first, not all unfair treatment is illegal discrimination, and that's a problem with the law, not with the client, and it can be very frustrating. Whether police are providing a service is often, the main kind of legal question when determining whether discrimination laws apply. But, it can also be difficult to actually prove discrimination based on the complex legal test, proving that, the comparator and the causation elements. Complaints and discrimination claims will lead to different outcomes, but they're both accountability mechanisms for the police force, so they are both available. And you can do both. I mean, you can make a complaint and anti-discrimination claim, but I would suggest you get legal advice first before you do either, because you want to make sure you protect your discrimination claim if you do have one. And yeah, finally on that point, each case will fall on its facts. We've got some broad kind of legal principles that apply, but each case is going to be different. So it really is important that you refer people to Redfern Legal Centre or another community legal centre to get advice about whether they have a viable discrimination claim against police. Okay, I'm going to answer some questions if we have any in the chat. Let me just have a look. Okay. Sorry, I'm just having. Okay, from Lauren. Yeah. Okay, thanks for your question, Lauren. Lauren says, I'm a domestic violence caseworker and have seen multiple misidentification cases. Yeah. Where, police have misidentified the primary victim as the perpetrator. Police facts are often logical holes based on assumptions. Perpetrators have used ABOs. Yep, that's right. We see this a lot. Yeah, look, misidentification is a significant issue that we see a lot at our organisation, and I know many other community legal centres see this problem as well. there potentially could be a basis to bring a discrimination complaint if it can be established that the police were providing a service to the person who had reached out. So maybe the primary victim was the one who'd contacted police seeking assistance. And if there's evidence to show that the police treated them unfavorably, so misidentified them and charged them as the perpetrator because of a protected attribute. So again, it's gonna have to come down to whether or not you'd be able to establish that they were treated in this way because of their protected attribute, as opposed to just dodgy policing or useless policing, or police just being kind of disinterested or not very good at their job. So yeah, it's definitely possible, but it would be potentially tricky to prove. But if there is a case where you think, oh, there's something in here that suggests that maybe the basis for this decision to charge this primary victim as perpetrator was a protected attribute, there's a comment that maybe was made by an officer, then I would encourage you to refer that matter to us to consider a discrimination complaint. Just see, I've got a question from Jackie. Hi, Jackie. I know I've spoken to you before. Will a court allow evidence based on data? Yeah, that is a really good question. So they do. The court will generally accept the evidence about like academic evidence about biases and data and issues with police engaging in conduct that might look like a sort of an unconscious, there's a clear unconscious bias against a particular group, or a pattern of conduct by police in targeting a particular group. That sort of evidence has been used. I mean, it was something that was relied on in the Weldon Bowen case. But it's not going like the court will kind of balance the weight to give that evidence, and it will be a question of is that evidence sufficient to prove those legal kind of tests of the comparator and whether police would treat somebody differently, or whether there's a strong basis to say that the discrimination or the unfavorable treatment was because of a protected attribute. So it's something you could bring into a case, but it will really depend on the decision maker to decide how much weight to actually give that evidence when deciding the legal question. Yeah, and that's just a comment about the LEC, which yes is fair. Yeah, there's a question about recognition of ethno-religious discrimination. It does. So you can bring a complaint under racial discrimination on the basis of discrimination on an ethno-religion. So that does apply under racial discrimination. Hopefully I've answered that. Yeah, and yeah, there are wait times, that's right. When you do provide a complaint, it often takes a long time for the Commission to deal with it. But yes, ethno-religions are covered by racial discrimination laws. Just a question from Casper. A common issue is around random street stops and searches, and given this is not captured by providing a service, does this simply mean that all actions would not be captured, or is it still specific, for example, name calling based on race where cleared, yeah, rough, more aggressive. Yeah, look, those generally no, when police are when police are exercising powers, discrimination claims are generally not available, even when, there might be pretty clear evidence that the police have engaged in discriminatory conduct. But that would still be a basis to bring a complaint. So absolutely, it would still be like a misconduct matter and should be raised as that. And there also might be other avenues to bring claims against police for, excessive use of force, or where, they've been more aggressive or rougher and not appropriately applied their search powers. So, they've decided to conduct a search for an improper reason, like, for example, just because they don't like somebody's race. Then that could be a basis, certainly, to sue police under other laws. And then the other point to just bring in here is that the Racial Discrimination Act would apply. So if the kind of street policing is discriminatory on the basis of race, then you might have a claim under the Racial Discrimination Act in discrimination. So I would still encourage people who experience these sorts of conduct by police to get advice, because even if you might not have a direct discrimination claim, you might have some other claim against police for their conduct. Sally says, many people we support are stopped and searched on the street, despite there being no legitimate reason. What's the best approach? So again, this is the same point. So when police exercise their powers like stop and search, they do have to meet a legal threshold. So the law sets out a test of what police need to establish in order to be able to lawfully stop and search someone. If they're stopping or searching somebody for a reason that's not supported by the legislation, or is unlawful, or, is purely based on perception about that person's protected characteristic, then that could be an unlawful stop and search, and that person might have a claim against police under other laws, so under what we call torts, for, conducting that search illegally. So that would be like potentially an assault, a battery, and false imprisonment. So I would still, encourage people in that boat to get some advice. If it results in a prohibited drug or something being located, and the person has to go to court, is being charged, then they should get legal advice to deal with the criminal matter, because the search and whether the search was lawful might have a bearing on whether or not the evidence could be admissible in court. And so they would really need to get some criminal legal advice. And then we could also come in later, when they've dealt with the criminal matter, to look at other options against police, a complaint, or whether there's a civil claim against police. I'll just answer, I think, Diane, and then we might have to kind of close it off shortly. So what experience, knowledge do you have about police liability for injury or death arising from pursuit of a driver? Yeah, that's kind of a separate issue. And I mean, if you've got a particular matter that you're thinking of that you would like legal advice on about police pursuits and the legality of police pursuits and police liability, that's something our service could provide you some advice on. So I would encourage you to get in touch with us. Just on that note, in terms of referring to Redfern Legal Centre, if you are seeking some advice from the police accountability practice, the best way to get in touch with us is by filling out the form on our website. So if you just jump onto our website, rlc.org.au, there's a form right there in the front, and you can complete that form with your details and legal question. You can complete the form on behalf of somebody else as well if you're a community service worker, and then we will assess the form, and hopefully we can provide some advice. I'll just do maybe one more question. Can a lawyer from CLC help a client identify an appropriate comparator? Yes, so that's right. So if somebody does think they've been discriminated against by police, we could certainly give advice to that person about the legal test, and based on the facts of that individual person's case, we can give advice that would include, this is what we would say the comparator in your case is, from what you've told us and the evidence we can see, there looks like there could be a basis for you to be able to establish that you were treated less favorably because of your protected attribute. Or maybe, the answer would be no, we think there's probably not enough evidence to establish that. So yeah, certainly we can give individualized advice to people about the legal test and whether or not they would likely have a viable claim. So again, I just encourage you to, if you do have a specific client or somebody who is who says they've experienced discrimination by police, that you refer them to us so they can get advice. All right, well, I might leave it there. Thank you, everybody, for joining today. I do hope that it was interesting and you learnt something from the session. And like I said, please feel free to refer to us, and we'd be happy to give advice about this sort of legal issue and other policing legal issues that you might have. So feel free to get in touch, and and thanks again for joining. All right.